Eric, thanks for jumping on. I will give a quick
Thank you.
intro into what we're working on here and a little bit about Eric, and then we'll jump into some questions, Q&A about general best practices when it comes to SBA acquisitions on the legal side, and then for general business ownership, what it looks like to structure things the right way, and what an ongoing legal practice should look like within your business. So, quick intro about what we're working on between Devin and I. We are bringing experts on from every avenue that you can think of, and just chopping it up with them, getting an idea of what is working in their industry, what business owners are asking to get some clarity on these dire questions that they have. And so we're periodically going through these talks for about 15 to 30 minutes. And about Eric, I actually met Eric about a year and a half ago when I started searching for, or almost 2 years ago when I originally started searching for a business to buy. And he was one of the first uh, experts that I came across on Twitter when it came to the legal side of SMB ownership and acquisitions and M&A, whatever you want to call it, the search process. And so he was a pretty prolific figure when it came to that industry on Twitter. So we've connected since, and I felt like it would be a good opportunity to hear from him, ask some questions that I've had, even some questions that Devin has as a business owner when it comes to the legal side of things. So I'll let Eric do a quick highlight of what he's working on, what he's seeing in the marketplace right now, and then we'll jump into it.
Thanks, Sean. Thanks, Devin. Eric Shu. I'm the owner of Clear Focus Law. Uh, I 100% work in the area of business acquisitions and specifically on buy-side representation, meaning 100% of what I do all day long, every day, is helping people buy businesses. I love this side and I actually niched in on this side of the fence about 3 years ago. Never really looked back. I've been a business lawyer for about 14 years and really just found this area of M&A work representing buyers to be exciting and fun. So that's all I've been doing. Closed over 100 deals, advise on tons of deals all the time, get on free calls with folks. This is a community I love. So I'm always interested in opportunities like this to chat about what people are wondering about, to share some stories from the front lines or some best practices or some legal background and insight. So happy to talk about anything that's going on right now or whatever people are curious about.
Cool, love that. With with your background, what interested you about M&A specifically? And were you out of university? Were you going straight into M&A and acquisitions,
Oh,
or no?
no.
Cool. Yeah. What got you
Actually,
interested in this space?
I have a kind of a long and interesting path to get here. Out of law school, I was a police officer. I did that for a while. Got injured on the job, retired, ended up being a prosecutor, ended up doing government positions, management positions, and really growing my practice on the side. So this, for many years, my business law practice was as a moonlighting gig. And so when I post a lot on telling people, if you want to escape your W-2, grow something on the side is a good way to do it in addition to buying something. So have multiple exit options. So I did that. And that's what got me interested in M&A, is kind of building the business law practice on the side. Really, what drew me here was the win-win. And so there's very few areas in law where at the end of a successful, whatever you call it, case, transaction, interaction, that if things go right, everybody is a winner and everybody walks away pretty happy. And there's a lot of collaboration. And
Right.
some lawyers get into the business because they love to fight, they love to break things, they love to tear things down. I hate that. This is much more. This is exciting and fun, building things. I did a bunch of startup work as well early on in my career as a moonlighting business lawyer. That was fun too, but the problem there was not a lot of things actually got traction. A lot of great ideas, a lot of cool people, a lot of people who were go-getters, but the results usually weren't there. There wasn't the funding, there wasn't the impetus, there wasn't the already successful ventures that people are jumping into and running with. And that's what's exciting about SMB acquisitions.
That totally makes sense. That's That's great. And to your point about like a win-win, I think the coolest thing about this space is that if a deal works out, and there's a, like you said, you've closed over 100 deals, so you've seen many people's lives change for the better when it comes to
Oh
these
yeah.
acquisitions, right? And it's funny that you preach, like, not funny, but it's great that you preach, like, hey, leave this situation or this like annoying, stressful situation and buy something uh, potentially more stressful and harder. Um,
Hmm.
but there is a lot of beauty to being able to operate something on your own that's been established for 30 years. And we'll talk a little bit about what it looks like to buy some of these businesses. But
Sure.
Devin, before I jump into some questions, do you have anything top of mind that you'd like to ask Eric, or just some pointers?
Yeah, one thing I think of with this stuff is like it makes me interested to know when it comes to acquisitions and things. I've had some friends who are really interested in learning more about it and potentially buying it, and like people that are looking to sort of move on from corporate life or maybe going through a transition or want to pick something up along the way. I'm wondering from your side what you think are like some non-obvious benefits of going through the process of acquiring another business, whether to start. I don't know if you work specifically on like people who are doing that for the first time, or is it mainly for expanding existing businesses? But I'd love to hear from you, like what kinds of exciting opportunities are there for people in 2025 and onward to expand their jobs, careers, and or businesses in that way?
Yeah, so I'd say about 80 to 90% of my clients are, they fit within one category. They are W-2s, they're successful, they've had a good career, and they're doing well. By almost anybody's standards, they're doing well, making good money, usually responsible for big things in their jobs, building things. But a lot of them are dissatisfied with corporate culture, building for someone else, quote unquote, having to ask for vacation, or now that there's a move toward getting people back into the office, loss of flexibility. People talk about just needing to really not be their own, not necessarily boss. It's a little bit of a trite word, but like being able to run their own lives. And I think this is all about freedom of choice, freedom of time, and being able to build something of your own. That's the number one, or I guess those are three things. Three of the top things that people tell me is what's driving them to do this. It's not for everyone. I mean, it really isn't. I'd say the majority of people who hear about ETA and think, hey, that's exciting. I can buy a business, I can run it, and so and so bought one, and their income went from 200K as a relatively well-paying W-2 to 500K, because they talk about how it's so easy. It's actually not easy. I just posted the other day that when I was in my W-2 life, if someone had a paycheck that was late by, I don't know, half a day, they'd be on the phone with HR, and they'd be demanding to know when it was going to show up. If it was 5 days late, they'd probably file a lawsuit. And when you buy a business, the reality is it's like you're behind the bank, your employees on payroll, the
Last
vendors you have
paid.
to pay off. Yes, if
Yeah,
you get
you are
paid.
now.
And someone posted kind of tongue in cheek that it's been a year and a half, they haven't paid themselves yet, and
Yeah.
you got to be okay with that.
Yep. Yep. Absolutely. You are now HR, essentially.
Right. Exactly. Call yourself, right?
Right. Right.
Nobody to complain to.
Yeah. Yeah. I love that. Great insight there. Okay. So if somebody's looking at buying their first business, or even buying their second, third, but they might not have had legal representation at all, or
Hmm.
solid representation, what are some landmines during the acquisition process that somebody should look out for when it comes to, whether it could be like the purchase agreement, it could be LOIs, it could be just
Hmm.
conversations between the seller and the buyer, or even the broker and the seller? Like there's a few things that I'm thinking of, but do you have any like major landmines that somebody should think about avoiding in that initial process leading up to the
Yeah, absolutely. Let
close?
me turn this thing off. It's a little noisy in the background. I'm going to start talking though. In the
Totally
meantime,
fine.
you ask a great question. I think there's a lot of landmines, and I think it can be kind of broken down into a few categories. So number one is dealing with the various players that you run into, brokers primarily, and then sometimes sellers. Like, how do you deal with these groups of people? Number two is like, what do you do pre-LOI that can get you in trouble? And then the transaction itself, I don't worry so much about, because I just tell people, you got to hire a lawyer that knows what they're doing. I can give ideas on what to look for and how it might go badly if you don't. But it's primarily these first two areas where people can stumble into it themselves and then find themselves in a bad position early before they think to bring in a pro. So number one, dealing with brokers. I find that increasingly there's a subset of brokers that are kind of like high pressure brokers. They're always telling you that this deal is so hot, there's like 10 other people looking at it, but the seller really likes you. And if you do something today, then you might be able to get this deal. And the something is something like, sign this LOI that I put together, or put down a lot of money because the seller wants to know you're serious. Don't worry, I'll hold on to the money. I've never lost $1 for people before. You know, that's the kind of stuff they tell you. Or, we're not taking LOIs. We only want serious serious buyers. So we want a purchase agreement, and don't worry, I've got one you can use. And those are, and then, you know, don't worry, networking capital, all that kind of stuff. Don't worry about it. Like, this business kind of runs itself, and these numbers are true. So people, you know, if they bite on any of those, God forbid, more than one, they could be in a really bad place. They could find themselves having signed a purchase agreement that's binding on them to buy a business that they know nothing about, that has very sketchy numbers on terms that no buyer at council would ever agree to. So those are some of the really tough situations people can find themselves in if they just kind of listen to this high pressure sales tactic that I see employed a lot by, you know, it's particularly in two states out there. I see that a lot in California and Florida. They've got kind of a built out form library for brokers to use. And those are horrible. Like, I get into discussions with lawyers a lot of times, like, how do brokers do this without actually violating the Unlawful Practice of Law Act? You know, like, how is that not practicing law when you give someone, here, just sign this, don't worry, it's a purchase agreement. And then they usually say, don't worry, there's contingencies. You can get out anytime you want. So they're giving legal advice on top of practicing law. So those are the landmines I recommend people keep in mind. And then when they start getting down into a deal that they're interested in, and they start getting the demands to do that, ideally, a buyer's already talked to advisors that they could call up and say, hey, this is what they want me to do. I'm really interested in this deal. Can you either help by giving your advice, sometimes on a CC email, saying, hey, this is what my advisor tells me to do. Are you telling me they're wrong? Or just giving some advice on how to handle it. So that's the early stage landmines that I see out there.
Yeah, that's great. And I think something I've noticed and I've heard a ton of in recently is that brokers do present a purchase agreement. There's a little bit of pressure, or a lot of pressure, excuse me, to just get that thing signed, right? Oh yeah, it's just we agree to those terms. Let's get it signed. Let's get this deal rolling. So you're saying when that purchase, before that purchase agreement might even be drafted, or if it does come from the broker, before you go back to the broker with negotiations or, you know, different terms, that's probably a good time to sit down with somebody on the legal side to say, hey, I just got presented our purchase agreement. We should review this together, versus me just going back and forth with the broker, who again is not a lawyer.
Yes and no. I would say yes, full stop. No, do not ever sign the broker's agreement. I will not use a broker's agreement, just about ever.
So you
they
would
are
redraft.
unusable. Yes.
Got it.
That's not the stage when a purchase agreement should be drafted. Brokers who are high pressure want to thrust that purchase agreement on unsuspecting buyers because it almost ensures that they'll close the deal. And in a lot of brokers' systems, as I understand it, they can get their commission locked in. So they basically have made the sale because here's the purchase agreement. It's signed by everybody. This buyer's going to buy it. The problem with those purchase agreements, they're horribly, horribly drafted. We're talking a typical M&A deal purchase agreement for a business of any size, let's say over 750 grand. is probably going to be 40, 50 pages, you know, a lot of detail, and then a number of exhibits, sometimes 5 to 7 exhibits. If you look at some of these form broker purchase agreements, they're like 10 pages. What are they missing? All the stuff that protects buyers. And then they insert a few things that protect brokers. Like they ask buyers and sellers to indemnify brokers from anything to do, and all sorts of things that should never be in a purchase agreement. So I've reviewed a number of these, and they're so unusable. Some of them don't even properly identify what assets are being purchased. Some of them, I mean, the California one doesn't even say that there should be a bill of sale signed at the end of the line. They just assume someone will draft one. So if you just use that, you could very well be in the position of being locked into a bad deal on really bad terms, and then at closing, not even getting the assets legally transferred to you. So there's all sorts of bad things that can happen. And I just recommend to people when they're presented with that to say, listen, I know enough to know this is not the time to be signing a purchase agreement. I'd like to provide you with an LOI. Maybe you could provide a good faith deposit if it makes sense, so that you can show you're a serious buyer, and let's do diligence, and then I'll have my lawyer draft my purchase agreement. That is what I recommend to all buyers.
I love that. Got it. When it comes to risk on the deal structure side, what are maybe 2 or 3 things that that a buyer could do to sort of mitigate their personal risk or their, asset risk, financial risk, whatever you want to call it? What are or maybe 2 or 3 creative ways that they could just mitigate that through maybe some specific verbiage or some, like you mentioned, some specific things in a purchase agreement that could help, again, mitigate that?
Well, first of all, I recommend people do some early background checks on the company and whatever they can find on the seller before they start paying someone to do anything. Once you get into the deal as a buyer, you're going to be out money for legal diligence, out money for financial diligence, and a reasonably good amount of times, if there's something bad out there, you can find it ahead of time with a Google search, with using AI assisted searching, and ask it to do a deep dive and profile the company, profile the sellers, get some open source intelligence free before you even dive in. That's my number one kind of like pre LOI risk mitigation, is just do some homework, see if you can prevent wasting time and money if the deal stinks from the outset. And then once you get into it, some structuring ideas for protecting yourself would include things like a seller note. I always recommend that a deal be structured with a seller note. There's some people, some brokers will say, I've never had a seller note at any of my deals. We're a seller's market. We don't do that. It's like, fine, okay, whatever. They might be selling to private equity, but by and large, the deals that you and I and folks that are listening to this recording are probably going to come across are deals with some risk in it. They're not the beautiful deals that go for cash to the broker's inside circle of like people that they know are going to buy right away. These deals are going to have owner dependency, customer concentration, or they're going to have lumpy revenue. And so, number one, seller note. Every single deal, I believe, should have a seller note. I think it does a lot of things, both psychologically. Sellers are less likely to be just untruthful in diligence. They're less likely to be just ghosting you during transition period, thinking you can handle it yourself. I'll move to the Bahamas, because they've got money on the line, and they're, whether it's $100,000 or it's $1 million on the line, it's psychological sharing of risk moving forward. And I think that also sets the tone that, hey, seller, you and I are going to share the risk and share the reward, because otherwise, if it's all cash close and no seller note, then the seller takes no risk, and all the risk goes on the buyer, and the seller walks away with cash. So that's not an equal allocation of that. And other things that I would recommend, and this one is an action, is to make sure that you involve tax counsel in your deal. There's so many tax implications, and even a lot that someone like myself haven't seen a lot of deals. I'm not fully up to speed on everything. So a lot of times I'll bring in tax counsel. I always recommend that buyers understand the difference between, for example, like a basic difference between a stock purchase and an asset purchase for both buyer and seller, the differences between stock purchase straight up or a stock purchase with an F reorg and a 336E election and things of that nature, so that you understand, because taxes will make a huge difference and they'll be big needle movers, and they can be a risk in a number of ways. Number one, if you structure a deal thinking you're going to have depreciation expense, for example, as a buyer, but you bought it as a stock and everything's been depreciated and you get zero depreciation, that'll impact your cash flow significantly. And on top of that, if another risk with taxes is that if the seller doesn't have good tax counsel, I've often seen it where, they might wait till the 11th hour and they finally send the deal over to their CPA and say, yeah, we're going to have to file a tax return on this transaction. Let me know what my taxes are going to be. And they were thinking it's going to be X, but it's X times 2, meaning they walk away with that much less money, and the deal breaks. Again, being a significant risk during the deal stage, because as buyer, you've already incurred, I don't know, 20, 30, 50,000 in diligence costs. And now the deal breaks because the seller really didn't understand how much money they were walking away with. So those are transactional risks that I recommend. I mean, first one, the seller note protects you from the post-closing operation of the business and things that might pop up. And then another one that a lot of people don't think about is protecting against past taxes. So again, coming to taxes, because it's a hidden risk. People don't really pay attention to it a lot. There's, they think, oh, if I buy it as an asset purchase, for example, then I'm not responsible for any of the taxes or the liabilities of the seller. That's actually not true. Taxes in most cases, unless they're personal income taxes, will follow the assets. And so things such as getting a tax clearance certificate, building that into your purchase agreement so you make sure you get that, or you close it through escrow for states that won't give it to you, so that you can ask the state, hey, how much money do we hold in escrow so that as buyer, I won't be responsible for the seller's taxes. And every state that won't give you a pre-closing tax certificate will do that for you. Washington, California, Illinois, for example, close a lot of deals where I've seen those states. They'll give you a number, and they'll say, hold this number of dollars in escrow, and then when we give you tax clearance, then you release it, and that way, as buyer, you won't be responsible for taxes. And then another hidden liability would be pre-closing sales tax for businesses that operate throughout the country. So if they sell enough in any other state, they're responsible for paying sales tax there. And then that's where, again, tax counsel, a lot of times in the form of a tax audit that a buyer can bring onto their onto their deal team, is another way to protect yourself.
Wow. Just going back to my deal, there's so many things that you just mentioned that I didn't even take into account, especially when it comes to taxes, especially when it comes to just structuring the purchase agreement as a whole. Like, there's so many pointers there that are so gold. And obviously, going back, there's a lot of things that I would do differently, but those are huge. And for anyone listening, that's those little tiny things add up so quickly. Like everything from working capital to the tax implications on a stock versus asset sale is so key, and that could be the difference between you being in business 5 years later or not. Like, that's how serious some of these little things are. So it's key. So thanks for sharing all that.
Yeah, you brought up a good point, and if it's okay, I'll touch on those.
100%.
There's things that should be in the LOI and things that shouldn't be in the LOI that I sometimes see. So things that I often see as missing, and then things that I see in there that shouldn't be. Number one on things that should be in there but often are missing is net working capital discussion. So for deals of any size, I mean, I'm not talking like 2 and under. 2 and under, a lot of times you won't get net working capital. That will just be a discussion between you and the bank. Once you start getting 3, 4, 5 and up deal size, it's common to request that net working capital be included. The problem I see is that people just put a statement they saw somewhere at a conference or whatever. It'll include net working capital so that I don't have to inject additional. It'll be determined in due diligence, and this is the formula. Well, the problem is you're not establishing an expectation in the seller's mind other than they'll provide some amount of net working capital. And I've had a number of deals die because that was the language that went in. So everybody knew they were going to talk about net working capital during the negotiations. But buyer thought, for example, they needed about 750,000. That was the number in their head, and that was the number their financial advisors were telling them. And the seller thought it was 250. So when you think about it, as you go through the deal, if the seller is thinking of leaving you $250,000, but you are thinking that you need $750,000, that's a pretty big bridge to gap, and that can kill your deal. So that's the one of the things that I recommend always be discussed. And you don't necessarily need to nail it down a number, but let them know this is about what I'm looking.
Huge. Huge. I love that. Cool. So for the sake of time, Eric, and thank you for this. This was super valuable. We're going to post this on LinkedIn. I'll likely post this on Twitter. I think we have some stuff going on YouTube as well. We're going to send this out to everyone, but where can everyone listening find you and connect with you if they're interested in learning more about you and maybe a deal that they're currently working on, getting some advice from you?
Yeah, thanks. I'm on X daily. So x.com, lawyer, the number 4 SMBs. I'm also on LinkedIn with the same suffix. And then I also have a newsletter. So I got about 1,900 subscribers. I go deep into deal structuring, how to really win on the deal life cycle between finding it, getting ready to, I guess as early as leaving your W-2, finding a deal, all the way to being under LOI. I cover that because I don't get to help people do that as a lawyer. So I'm trying to help people be smarter there, going into a lot of deal psychology and how to win at that stage.
Love that.
And that's buyersblackbook.com.
Awesome. Yeah, great newsletter, by the way.
Thank you.
Cool.
Appreciate you reading.
Thanks, Eric.
Thanks, Eric.
Well, thanks for having me, guys.
Yeah,
You too.
absolutely.
Take care.
Talk to you
Bye.
soon.